Welcome to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime, 1-800-DeWitt-LAW, or interact with the show by sending an email to ask@dewitlaw.com, or you can also call 407-53-MOSES. Every Sunday morning at 10 a.m., you'll learn how Florida's legal issues affect you with your host and expert, Moe DeWitt of the DeWitt Law Firm. Moe will answer your questions to discuss the latest legal issues affecting the citizens right here. So I guess it's the holiday edition of the show.
Yep, July 4th weekend. Hopefully everybody's out there having a great weekend, relaxing with the family, maybe doing a little barbecuing or something like that. But of course, we're still here bringing you the latest legal topics impacting the citizens of Central Florida, because that's what everybody wants to listen to on July 4th weekend, obviously.
Yeah, but it's great advice, So,
well, it is, and there's been a lot happening in the Florida legislature this year, which has been really interesting and really fun for us to follow. And, one of the big topics we've been following this year is, of course, the alimony reform bill, which was set to end permanent alimony in the state of Florida. And we've really been following it since it was originally introduced in the House and the Senate at the beginning of the legislative session. And it's had quite the journey.
Right.
So, at the beginning of this whole thing, we said, if it was going to be passed, there's most likely two provisions that it will not include this time. And that was that alimony will be retroactively, the end of permanent alimony will be retroactively applied, and the automatic 50-50 presumption for time sharing or child support in Florida. Of course, the version that they passed had both of those provisions in it. And then it went to the governor's desk. And that's where it's been sitting up until about last week when he finally acted on it. So I know depending which side of the fence you're on, you may be happy, you may be very unhappy. Obviously, the listeners out there, depending if they're paying alimony or receiving alimony, they have a different perspective on this. I certainly understand that. But the governor has officially vetoed the bill, which means that we're back to square one. We're back to the existing alimony statute that we've had in Florida for probably over a decade at this point. So really all this, this bill that they passed really did no good because it got vetoed.
Right.
And the interesting thing, which we've talked about on the last show, was the governor in his veto specifically said that because it includes the retroactive portion, that, it would end permanent alimony retroactively.
Right.
Meaning that would affect all existing divorces where alimony is being paid on a permanent basis, that it was unconstitutional. And so that's what we talked about before. And, whether you like his decision or dislike his decision, I think you certainly have to respect the fact that he's trying to avoid extensive litigation in the courts, which would ultimately probably lead to the conclusion that it's unconstitutional anyways, which then does nobody any good because it just creates a bunch of litigation, a bunch of cases, a bunch of people spending a bunch of money on attorney's fees, which I'm sure the attorneys appreciate, but really doesn't do the citizens any good.
Right.
And so, on one hand, it's very frustrating that the legislature passed a bill like this when, this is not the first rodeo where this has been called unconstitutional. That's why Governor Scott previously vetoed it. He believed it was unconstitutional as well. You have the Florida Bar, the family law section of the Florida Bar standing there saying, hey guys, this is going to be unconstitutional. The legislature said, hey, we're going to push it through. We don't care, or whatever their rationale was. Maybe they believed it wasn't unconstitutional. Ultimately, it gets to the governor's desk and he said, nope, unconstitutional, got to start over. So now we're without any sort of solution again. We'll see if it comes back in the next legislative session.
So I have this is the layman's question.
Of course.
Why? Why do they keep trying to push it? Because it keeps getting bounced back. So why do they keep trying to press the issue when they governor keeps saying, no again, and no again?
Well, I think that's beyond a layman's question. That's really more of an inside the legislature question as to what are these people thinking, right?
Yeah.
And ultimately, I'm sure certain politicians have certain agendas. Maybe they have certain personal experiences, and they believe that they're putting that into this bill.
Okay.
Or they just don't know how to learn their lesson from the last time it got vetoed.
Right.
I don't know. But when we started this discussion, I had a conversation with Chris. I said, if this is going to get passed, these two provisions will not be in it. And of course I was wrong. They put both of those in it, which ultimately led to it completely killing the bill. So why they do that, your guess is as good as mine. Maybe there's maybe they wanted the bill to get killed. Maybe they wanted to say, oh, I pushed for this, but ultimately they knew it would get killed.
Right.
I don't know. That's behind the scenes of the Florida legislature, not something that they've pulled back the curtain on for me yet. But, it's going to be back again, whether it's next year or down the road. I'm sure we're going to see a new alimony reform bill at some point. You just hope that they actually get serious about it. They know what these issues are. They know that the two big hot button issues that will most likely get the bill vetoed or possibly overturned by the courts if it's not vetoed. So hopefully they introduce a bill that actually does some good rather than basically just wasting everybody's time.
It's the DeWitt Law Review on 107.3 FM and AM 580. Our expert, Moe DeWitt, he's taking your calls. If you've got a question, something you want to know, you can always email us right now at ask@dewittlaw.com or by calling 407-53-MOSES. That's 407-53-MOSES. We're going to get to some questions here in just a second. Is there a general calculator, like if somebody's trying to figure out alimony that you can kind of use? I know it's different, and I'm sure in every situation, but just a basic calculator.
So under this new bill that was introduced, it was basically going to be a formula similar to child support. Okay. So you plug in the numbers, and of course there's some argument of what the numbers should be, what your income is, what this is, so on and so forth. But the new bill was basically going to be a calculator or a formula.
Right.
Right now in the state of Florida, the actual standard is need and ability to pay. So what is the person's need receiving the alimony? What is the person's ability to pay who's paying that alimony? Now, there is a calculator, so to speak, that's put out there by the American Academy of Matrimonial Lawyers. But it's not law. It's a guideline. And last I checked, they hadn't updated that guideline for the change in the tax code that occurred a few years ago.
Okay.
So it's kind of out of date. People used to use it as a guideline, an estimate, but it's certainly not the law in the state of Florida. Judges are not required to follow it at all. It can be used as argument in some cases, but that's really about it. And certainly, now it's a bit out of date because it really doesn't account for that big tax change where alimony used to be paid as an off-the-top deduction with pre-tax dollars. It's now paid with post-tax dollars, which obviously limits the amount that people can pay. So there is kind of some guidelines, some formulas. Typically when we're trying to figure out how much alimony you're going to be paying or you're going to be receiving, we're looking at the financial affidavit that you fill out as part of a divorce. So in all divorces, which is one of my clients' least favorite things to do, is you have to fill out a financial affidavit, which basically goes through all the expenses that you have on a monthly basis, all of your income on a monthly basis, all of your assets, and all of your liabilities. And of course, nobody likes people digging through their finances.
But you got to know. You
got to know. So, I don't know what the percentage is, but a lot of times when we send that to people, say, hey, we got to start working on filling this out there. I'm not giving the court this information. Well, you're required to. That's part of any divorce. I know it's not fun. The divorce process is not fun, but that's just part of the process. But at the end of the day, when we look at the financial affidavit, what we're going to be calculating is, based on your income versus your expenses, do you have a deficit or do you have a surplus? And then, based on the deficit and surplus of each party, that's how you're going to start to kind of calculate what the potential alimony would be based on those expenses. And of course, people try to overstate their expenses, and you have to go through them and say, no, that's not really accurate, or understate their expenses, or whatever it may be. But that's where, then you're starting to compare the financial affidavit with the financial documents that you receive as part of the divorce to see if they're actually accurate. And so it can be a tricky process, and it does take some time and can be a little annoying.
Speaking of divorce, is there, maybe somebody listening right now is considering it, or maybe somebody is already 3 weeks into it or 3 months into it. Is there in the state of Florida, is there a set, it usually takes 3 months or it takes 2 years. And again, I know every one of them can be different, but as far as like that's the norm.
So I kind of give a timeline typically to my clients. So if it's a true uncontested divorce where you guys agree to everything, basically you've sat down, you've reached an agreement, you're just hiring an attorney to draft everything up, make sure it's legal. Usually in most cases, you can get that done in 30 to 60 days.
How often does that happen?
Well, everybody, or not everybody, but a lot of people call and say, hey, it's going to be an uncontested divorce. We think we have an agreement, but then when we start talking about the details, that agreement breaks down or they're much further apart than they had hoped.
Okay.
The second kind of category that I usually use is kind of where you resolve the case at mediation. And probably, 92% of cases resolve at mediation. And it probably takes about 6 to 8 months to get to mediation. So if you go to mediation, you resolve it there, you usually look about 6 to 8 months. Now, If you're actually going to go to trial and resolve it at trial, I used to say a year. I'd say it's probably actually more like 18 to 24 months now, because we are dealing with a backlog from COVID still. There's still just a backlog of cases.
Right.
And frankly, a lot of counties just don't have enough judges. They're underfunded. They don't have enough judges to handle all the cases that they need to. So I'd probably bump that up to about 18 to 24 months from start to completion if you go to trial. And the other problem we've had is because judges are backed up. We go to trial, the judge says, okay, I'll make a ruling, and it takes them another 6 months or a year to actually issue the documents, which is super, super frustrating for the client.
Sure.
Because this is not a fun process. People want to get this process over with and move on with their life.
Absolutely.
Right. Yeah. So, that's one thing we have to kind of counsel people with is in the beginning, you may be gung ho, I want this, and this. By 2-3 years, you just go, I just want to be over with this. I just want to move on with my life.
Put a bow on this and let's go.
Right. So you got to balance that and kind of advise people on the best way to proceed to accomplish their goal, right? Because everybody's goal is different. And of course, you don't want to give away the farm just to get it over with either. Right. So that's always what we're looking at. And, depending on what county it is, what judge it is, there may be different time frames, of course, and depending on the complexity, if one party's not cooperating or being more difficult, that could also extend the time frame. So, of course, it is, unique to each case, but those are just kind of general timelines that I give.
When it comes to a couple saying, we've decided that we're going to separate, we're going to get a divorce, is there a common, or has it happened where you see it more times than not, where somebody comes into you and either the, not necessarily your client, but maybe their ex, their soon to be ex, you're like, maybe it is your client. So let me rephrase that.
All right.
Where you're like, I wish you wouldn't have said that or done that before you came to see me. Like a common mistake that people make, like, I'm going to get you for everything you have, or like hiding money in a separate. I'm sure that there's, people get devious and stuff. And before they come and seek your professional expert advice, it's like, oh, I wish you wouldn't have done that.
Yeah. I mean, obviously divorce is a very emotional process. And so I think sometimes up front, people can do things that are vengeful in certain aspects.
Because you're mad. Yeah.
You're mad. Of course, the worst case scenarios are domestic violence, and you should never do that. And when that occurs in a case, it does make things a lot more complicated, especially when it involves children and things like that. But there's also a lot of financial vengeance that can go on where people are trying to hide money, or they're trying to starve the other party out by restricting money and things like that. And ultimately, any action that you take in a divorce, whether it's before the divorce is filed or during the divorce, you have to remember that that's probably going to be shown to the judge. Any communication, any text message, any Facebook post. One of the worst things I've ever seen is the other side had the child, and the party knew the other side had the child, and the other side was supposed to have the child. And the person who did not have the child went on social media and posted what they called an Amber Alert, that the child was missing.
Oh, no.
Now, when the judge saw that, the judge was not happy about that.
I'm sure.
Because now you're basically accusing the other parent of kidnapping the child, even though they had the right, they were rightfully entitled to have the child during that period of time.
Oh,
so,
man.
Just remember, anything you post, anything you text message, any voicemails you leave could be played or shown to the judge once you ultimately get in front of that judge.
Same thing we tell our kids.
Yep.
Be careful what you put out there, because you can't get it back. It is the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. We've got some questions from listeners coming up here in just a few minutes. Brian's got a question as far as getting a ticket when you get into some sort of accident when it's a no-fault state. So we're going to tackle that question coming up in just a few minutes. And again, if you've got a question, you can always email it to ask@DeWitt Law. It's DEWITT Law. ask@DeWittLaw.com, or by calling 407-53-MOSES. More of the DeWitt Law Review coming up on AM 580 and 107.3 FM, Orlando's News and Talk.
Oh, hey there. I was just staring at this check that we just got for $20,000 for a guy who was hit by a car while riding on his one wheel. The initial offer in this case was just over $3,700. That's well over 6 times the initial offer. And that's why you call Moe.
You are listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk. Thanks so much for joining us. Once again, we are here with Moe DeWitt of the DeWitt Law Firm. All right, Mo, if people want to get in a question or they've got a comment and they want to reach you, how can they do that?
So, I mean, with anything on the show, if you have a legal question, you can always email us at ask@dewittlaw.com. Or if you want to leave a voicemail, it's 407-536-6737, which coincidentally translates to 407-53 Moses. But you can also text that line too. And, I'd be curious, because we've been covering this alimony reform bill for so long, basically the entire year. I'd really be curious what the listener's opinion is. Should the governor have vetoed this? What do they think about it? So if you want to leave a voicemail or a text just telling us what you think about it, what do you think he should have done in this situation? Do you think it's fair? Do you think it's unfair? I'm always kind of curious to get the listener's perspective on these kinds of things, because ultimately those are the people who this is really impacting on a daily basis.
Right.
And given that this has been in the legislature for the better part of a decade at this point, I mean, this is the third time an alimony reform bill has been passed and has been vetoed by a Florida governor. Of course, this is the first time with Governor DeSantis, but Governor Scott vetoed it twice for similar reasons. So, I really would like to hear, from the listener's perspective, what do they think about all this? Okay. It's been going on, and I know a lot of people have very strong opinions, especially if you're paying or receiving alimony.
Yes.
But even if you're not personally, usually you have a friend or a family member who is paying alimony or has paid alimony in the past. And of course, nobody likes paying alimony. I've never met anyone who likes paying alimony,
right,
but it's part of the society we live in. But the big question always revolves around permanent alimony, and whether permanent alimony is fair, unfair, obviously depends on your perspective. But the alimony reform, or excuse me, the alimony bill that's in place has been there for a long period of time. A lot of people would say it's outdated at this point in time and needs some reform. So curious to see what the people out there think. So they can leave us a voicemail, 407-536-6737. You can also text that number, or shoot us an email, ask@dewittlaw.com, whatever's easier for you. It's ask@dewittlaw.com.
And that's exactly where we got this one from. This comes from Brian. He said, always wondered why law enforcement officers issue citations for crashes in Florida if it's a no-fault state. Why does that take place?
So a little bit of a funny misnomer there. So we're a no-fault state in the sense that we have no-fault insurance, which is what the PIP, or personal injury protection insurance, is.
Right.
And so what that means is if you're in a car accident, whether you're at fault or not, you have up to $10,000 in benefits to go see a doctor if you get hurt. You have to go within 14 days and all that kind of stuff. But the idea is basically whether you're at fault or not, you can go get checked out by a doctor and you have that insurance. And that's one of the few insurances that's mandatory for everyone who's driving in Florida. But that doesn't mean that we're a no-fault state in the sense that we don't assign fault for car accidents. So if you hit somebody and hurt them, you're still responsible for the damage that you caused. And that's why you should have insurance to cover those damages.
Okay.
And that's why law enforcement officers can still issue tickets for those damages. And in the accident report, typically, they say that one person is at fault, or maybe multiple people are at fault for the accident, depending on how many people were at fault. But we still definitely assign fault in the state of Florida. When we say we're a no-fault state, we're just one of the states that has this no-fault insurance policy provision, basically. Now, fun fact, we're one of the only states, I think we are the only state in the nation that does not require bodily injury insurance, which is the insurance that if somebody hits you and hurts you, that's the insurance that you go after. And so that's why I always preach on this show that it's extraordinarily important to have uninsured motorist coverage on your policy, because if someone hits you and hurts you, they don't have to have the insurance to cover the damage they caused. And so if they don't have that insurance, then your uninsured motorist coverage steps into the shoes of the at-fault driver. It's legally not allowed to raise your rates unless you've had a certain number of accidents within a certain number of years. And then you can go after that policy to recover the money for your damages.
That's good to know. Because we were just looking at my mom needed new insurance. We were just kind of shopping around, and that was one of the things. And I was like, Mom, well, I've heard you definitely, I've heard most
good insurance to have.
You want to make sure that you definitely have that covered. All right. So we've got some more questions from listeners coming in. Again, if you want to ask a question, if you go to ask@dewittlaw.com, or you can call 407-53-MOSES. That's 407-53-MOSES. You can also text that number as well. Whether you've got a question about at fault, whether it's traffic, whether it's car infractions, accidents, family
throw it all at us. We'll try to answer it.
Bring it on, right?
Yep.
All right. It is the DeWitt Law. It is the DeWitt Law Review on 107.3 FM and AM 580. More coming up with Moe DeWitt on Orlando's News and Talk next.
I've told you before, I'm going to tell you again. Right here's a check for $25,000. Initial offer was $7,000. On average, with an attorney, you get 3 times more than those who go at it alone. Injured on the go? Just call Moe.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. Here with Moe DeWitt of the DeWitt Law Firm. Moe will answer your questions, discuss your latest legal issues affecting citizens right here in Central Florida. If you've got a question, ask at DeWittLaw.com or by calling 407-53-MOSES, and you can also go to DeWittLaw.com. All right, questions are coming in, all right? Holiday weekend edition of the show.
What we're here for.
Somebody wants to know, here's my situation. A few years ago, my dad applied individually for a retail Lowe's credit card. And after a few months, he added me as an additional user, which gave me my own card. Said he didn't provide his social, his income, any of the other information that you usually have to give when you get a credit card. All right. Well, since then, Lowe's, they said, switched the credit card company that they use, and they shut my dad's old account off, which was in good standing. But now the previous card company is coming after my father as well as myself, even though I provided no info other than my name and agreed to no terms. Am I on the hook for any kind of debt, which is being reported on my credit currently?
So there's kind of a few layers to that question. So we'll start with the credit report aspect of it. And I'm certainly no expert when it comes to, cleaning up your credit report or anything like that. But I have had clients before in this situation, and when they went to the actual credit reporting company and explained to them that they were just an authorized user and they did not sign on to the actual credit contract, they removed that derogatory item from their credit report.
Okay.
But to do that, you have to go to all 3 main credit reporting agencies. You can pull your credit report from there. I think it's Experian, TransUnion, and there's another one out there. So I'm sure somebody can call in and tell us what it is. And you go in, you dispute the item, you explain that. And I have had, again, this was from clients that I've worked with, it being removed off their credit report.
Okay.
Now, from the civil side, let's say that his father didn't pay the balance on the credit card. She says it was in good standing, but then maybe later on it was paid or it was late or something like that.
Still owe something, yeah.
Still owe something. So if the credit card company actually sued him for that, they would have to show that there's some sort of contract between the authorized user and the credit card company, which typically there's not. Typically, that authorized user did not sign something saying that he would be personally responsible or basically a co-guarantor on the credit card as an authorized user. So therefore, they wouldn't be able to sue him. They'd only be able to sue the person who entered into the contract, because a credit card is just a contract with the bank, essentially.
Right.
You're saying, hey, give me a piece of plastic. I'll pay you on a monthly basis. If I don't pay it, I'll pay this amount of interest, whatever it may be. So it's just a contract, essentially. So the question becomes, are you a party to that contract or not? And if you are, then you're liable for the debt. If you're not, then you're not liable.
Yeah, because, you think when you do a credit card application, you fill out that little pamphlet or whatever, you always got to put your signature underneath all that small fine print,
Right.
And if he never signed, then, yeah, I would assume that he would be okay, but Dad's certainly not off the hook.
Right. Now, nowadays you probably do it electronically, where you read 3,000 pages of documents, or you pretend you read them and you say, I agree, and you check the box and you type your name in. But if you didn't do that, if you didn't agree to be a guarantor of that credit card, then you're not going to be liable if they sue you. But as we've seen here, it can still impact your credit score, your credit report. Like I said before, clients I've worked with in the past were able to get that taken off. But obviously, that's going to be between you and the credit reporting agency.
All right, we're going to turn pages here just a little bit. We were talking about uninsured motorists,
Yep.
Right? So Brock heard us talking about that and wants to know, if uninsured motorist covers only my medical bills, why is it necessary if I have total medical coverage through Medicare and VA benefits?
So the problem with the question is, it does not just cover your medical bills. That's one of the things that can cover. So
Okay.
if you're, like we said before, if you're hit and hurt by somebody who does not have any insurance, any bodily injury coverage, or does not have sufficient bodily injury coverage, then your uninsured motorist coverage can step in and provide coverage for your medical bills, pain and suffering, lost wages, basically any damage that's caused by the accident. So it covers a lot more than just your medical bills alone. And so that's why it is so important, because let's say you're hit, you're injured, and you can't work for 6 months, or maybe you can't work at all. That's where that insurance could step in and provide some coverage beyond just basic medical bills. It's going to cover the pain and suffering. It's going to cover the lost wages. It's going to cover all the damage that's normally associated with a car accident case. The other kind of cool thing about uninsured motorist coverage is it can also cover you when you're not even in your vehicle. So let's say you're out riding your bike, you get hit by a car, that car doesn't have sufficient insurance. Even though you're not in a vehicle, your uninsured motorist coverage can still cover you there.
Oh, wow.
Because you were hit by a car that was underinsured or uninsured.
And so, like you said earlier, that can't make your rates go yours if you have a claim. Is that right?
Right. As long as you don't have a certain amount of accidents within a certain amount of years. Now, they can take off, what's it called? When they bundle stuff and give you a little discounts.
Yeah.
They can remove the kind of like good driver discounts. But they're legally, by Florida statute, not allowed to raise your rates for making a claim against your uninsured motorist coverage. And obviously the reason for that is because that's really, it's not a no-fault coverage, but it's supposed to step into the shoes of the at-fault driver. So it's not something that you did wrong. You didn't do anything wrong. It's there to protect you if somebody else does something wrong. So if even if you're just sitting, let's say you're sitting outside at a cafe or a restaurant, car runs off the road, hits you while you're sitting there eating your lunch.
You've done nothing wrong. Right.
And your uninsured motorist coverage can cover you in that instance. So it's pretty interesting cover. To me it's cool. Maybe not to the listeners, but it's really good coverage to have. I highly recommend everybody out there check their policy, call their insurance rep, ask them do I have this coverage. It's usually not that much to add depending on the policy.
Right.
But when you buy insurance coverage, we talked about this before. A lot of times you just call your rep and say, hey, give me whatever's the best deal. And they may not give you uninsured motorist coverage. You don't even know it. They just don't add it to try to save you a few bucks.
Make it sound cheap.
Right. But if you get into an accident, especially in the state of Florida, I think last we looked, it was like almost 50% of drivers did not have bodily injury coverage in the state of Florida. So, you're flipping a coin, basically. If you ever get in an accident, will the person have any sort of coverage to cover me? And, the thing we deal with, especially with catastrophic accidents all the time, is there going to be coverage, and is it going to be sufficient? People who have been in the hospital for weeks and can't work for months, and there's no insurance coverage, and it's kind of heartbreaking to have to tell the client, hey, there's no insurance coverage here. There's not a lot we can really do for you.
I mean, you can imagine the stress. You're already injured and everything, and now you're out of work, and now you've got these bills that are starting to pile up on you.
Yeah. I mean, it can be really life altering. It can really send people down put them in a really bad position.
But that is good to know. I mean, you think of people when they, if you get into any kind of accident and you want to go now and rely on your insurance to help out with these coverages. I couldn't imagine being just a person riding a bicycle down a street, somebody crashes into you, and then you're too afraid to call your insurance company because you're afraid that your rates are going to go up. You already got medical bills. Now your rates are going to go up. So that is good to know that that's not your fault.
Right. Exactly. And that's why that provision is there. But, I always say you can't rely on anyone else in this life. So that's why you can't rely that other people are going to have insurance coverage to cover you if they injure you. That's why you want to have uninsured motorist coverage on your policy, because you want to protect yourself at the end of the day.
There's somebody listening right now on the radio, and they're sitting at a red light, and they just turned over and looked at the car next to them, and they're just kind of eyeing them like, I wonder.
You got insurance over there, buddy?
If not, get away from me. Basic question here.
Yeah.
You get into a car accident.
Mm-hmm.
Do's and don'ts as far as immediately, because everybody's shell shocked immediately when it happens. And do you move your car? Do you not? Do you call the cops? It's just little damage. I'll pay for it out of my own pocket.
So here's kind of the three tips I kind of typically tell people. And the first one is, call the police and get an accident report if you can. And the reason for that is when you go to get your vehicle fixed, even if you're not injured, if you have an accident report, it's going to make the process go a lot faster, because the first thing the insurance company has to do is determine who's at fault for the accident.
Okay.
Well, if they have an accident report, it speeds things up a lot faster, because if they don't, what they're going to do is they're going to wait to call their insured or call all the parties in the accident and try to figure it out on their own. Now, typically what happens in that situation, who's ever at fault for the accident doesn't answer the call from the insurance company because they don't want to talk to them.
Imagine that.
Yeah. So then now you're spending weeks or months trying to chase down the person to speak to them before the insurance company will make a determination of who is at fault. If you have an accident report from the police, it will usually speed up that process quite a bit.
Okay.
Now, the frustrating thing is if you're in an accident, over here on I-4 or, anywhere in Central Florida, it can sometimes take the police several hours to come out. I've even had people have to wait 4 and 6 hours. So it's not fun. I get that. And people say, oh, we'll just leave. I don't want to wait around.
Right.
Ultimately, you can leave. It's always up to you. It's your decision, but it could make things a little more difficult and delay things down the road. The second thing, of course, is take pictures of everything. And, I typically recommend, I was talking to the guy last week and got in an accident. They pulled over, was talking to the guy and said, hey, we should call the police, get an accident report. The guy says, all right, great. Let me go get my insurance information, driver's license out of the car. Walks over the car, hops in, takes off.
Oh, no.
And so he was able to get a partial license plate at least and some videos of him driving away. But I recommend as soon as the accident occurs, take a picture of the other driver's license plate right away and start taking pictures of everything. You want to take pictures of the damage to the vehicle, take a picture of the person driving. I've had people deny that they were actually driving before and say it was their friend or somebody else in the car. And then the insurance company's going, did you guys switch seats? What's going on here?
Yeah.
So take pictures of everything, the surrounding roadways. If it was at an intersection, take pictures of the intersection. Try to get as much information as possible because once you leave that accident scene, that information is not going to be there any longer, right?
And now with phones, everything, time, date stamps, everything. So you've got all that proof. That's helpful, I'm sure, too.
No, I mean, I remember, probably 15 years ago, attorneys would say, oh, keep a disposable camera in your glove box, which I don't even know if they make disposable cameras anymore.
I don't know.
But now it's so easy with phones. You can just pull out your phone and take pictures of basically everything. But that's not the first time I've had that situation where someone drives off like that. So, even though you may not think of it right away, maybe even before you get out of the car, through the windshield, just take a picture of the license plate of the other driver in case that does happen.
Good to know. Okay.
Because for some reason people get a little nervous when you say, hey, we need to call the police to get an accident report, and they might just take off.
Gone.
But not a good thing to do, by the way.
No.
You usually get caught on that, so don't do that. And third, of course, is if you are even feeling a little bit injured, and us as guys have the worst tendencies when it comes to this. You say, oh, I'm just a little bit sore.
Right.
Not a big deal, and we won't go get medical treatment. You want to get checked out right away. And the reason for that is, typically if you're feeling a little soreness out after an accident, it's only going to get worse over the next few days. And I actually had a good friend of mine who was in a car accident. I was actually in the vehicle. He was in the back seat. So he took the brunt of the damage and, did not go get medical treatment. And then years later, the damage from that accident got so severe where he actually had to have a couple discs replaced in his vertebrae. So it became quite serious because he didn't get that treatment up front, didn't get checked out. And of course, then, the insurance company's going to say it's not related to the accident because it happened, you had the disc replacement so much later. So it can be a real headache. So even if you're feeling a little soreness, get checked out. Make sure there's nothing wrong, serious going on there. You don't have any torn ligaments or disc herniations. It's just good to get checked out, get a thorough examination. We always want to say, oh, we're tough. It'll go away. I'll be fine. That's how you get yourself into trouble. Especially sometimes there can be internal bleeding that can kill you, frankly.
Right.
So
especially when you wake up the next morning and you're like, my back felt fine. Now I woke up this morning. It's like, okay, I feel like literally I got hit by a truck.
Right. And I hear that all the time. And, a lot of times people will wait to call us, till they kind of get to that point and go, okay, you need to get checked out by a doctor, give your doctor a call, go to the ER, go to the urgent care, whatever it may be. You need to get checked out and make sure that there's nothing serious going on there. Because at the end of the day, the number one priority with any accident case is to get the person to be, as good as possible, get them back to being as good as possible down the road.
We got to take a break here in just a second, but as far as somebody just wanting to switch info with you, if it's not a lot of damage, is that okay? Or would you, it's like a minor fender bender, $300.
Right. Well, here's the problem. As an attorney, I'm always trained in worst case scenario, right? So I've seen the worst cases. So, that's why I always say, hey, call the police, get an accident report. Of course, you can always exchange information, take pictures, and go that route. Mm-hmm. There are risks associated with it. And, I see the worst of it. So I always say, hey, call the police. But of course, you can just do an exchange of information if you want to. But, sometimes it can be risky. Actually, years ago, I did that. Before I was an attorney, somebody hit me. Mm-hmm. And it was just a little bit of damage on the bumper. They had to swap out the bumper. And she said, oh, no problem. I'll take care of it, yada, yada. So I went, got a body shop estimate, sent it to her. And she goes, I don't know what you were talking about. I wasn't there.
Oh, no way.
And I was like, well, I have
so
your driver's
wrong.
license. I mean, I have your information. And I mean, it wasn't a ton of damage, so it wasn't, really worth pursuing at the time. But I was just, that's scummy,
And that's when he knew that moment he was going to be an attorney.
Exactly. Like, I'll get that lady one day.
All right. So more of your questions coming up in just a few minutes. You can always send them to ask@DeWittLaw.com, ask@DeWittLaw.com, or by calling or texting 407-53-MOSES. That's 407-53-MOSES. A lot of great information and being able to interact right on the website as well, with as far as the live chat and everything goes too. If you go to DeWittLaw.com, got some more great advice for you coming up in just a few minutes. It is the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
So I want to show you something. Here, come closer. See this letter here? This letter offered for our client to settle for $10,000 back in May of 2021. We just got this client $200,000 for that same accident. He didn't want to take the $10,000, and rightfully so, because the insurance company was offering him pennies on the dollar. Oftentimes, clients get impatient, but in this case, it was worth the wait and worth to fight the insurance company to get what he deserved. Injured on the go? Just call Moe.
You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. Every Sunday morning, right here at 10 a.m., you'll find out how Florida's legal issues affect you with your host, Moe DeWitt of the DeWitt Law Firm. All right, Moe, we've got another question. I think we have time to squeeze it in here,
Let's
hopefully.
do it.
Again, and even if we don't get to it this week, if you want to get to it next week and you have this question that you're just dying to know the answer to, you've got Moe here willing to give you his advice, his opinion. It's ask@DeWittLaw.com, ask@DeWittLaw.com, or by calling 407-53-MOSES. All right. Justin wants to know, he's probably hear this a lot. He said, when determining child support payment amounts, is it possible for the two sides to agree on a number that is fair and reasonable to pay, or does it have to be the amount set by the Florida child support calculator?
So technically, when it comes to child support, it has to be by the calculator. And the reason for this statutorily is the child support does not belong to the parents. The rights to child support does not belong to the parents. It belongs to the child. Even though you pay it to the other parent,
Makes sense.
it belongs to the child. Yeah. So you do have to go through the child support calculator, the child support formula. But it's important to make sure that you're actually calculating it correctly. Because even though it looks kind of simple, there are some intricacies to it. So, first thing is you want to make sure that they're properly calculating the taxes when you put your income in. You want to make sure you're including the right income when you're putting your income in there as well. But you also want to make sure that they're properly tax affecting that, because child support is supposed to be based on your net income, not your gross income, minus, mandatory deductions and taxes. From there, of course, you also want to make sure you're including the proper health insurance costs. And if there's any daycare costs, you want to look at those as well. So you want to look at all the factors that go into it to make sure you're actually calculating it properly. So I see a lot of times people just completely miscalculated and they think it's some huge number or some really low number, and they go, I don't know what this is, yada yada. And so a lot of times we look at it and say, okay, you calculated it properly, can't really do that. Now sometimes every once in a while you can ask for a deviation in the child support guidelines as well for certain reasons. So you can ask for an upward deviation or downward deviation, and then if the child support's de minimis, meaning basically it's under $50 or so, a lot of times the judge will let you waive the child support in those instances, because basically it's de minimis. So you can just agree kind of, hey, we're not gonna send, $12.72 back and forth every month. We'll just call it zero and call it a day. The only other time I've seen the judge allow child support to be waived is if one party is paying for some expense for the child kind of in lieu of child support. That may be private school. It may be,
Competitive cheer.
Competitive cheer is expensive.
I know, that's why I say that.
That usually falls under the extracurricular activities, but again, it's a case by case basis, and it depends on what the judge will allow in those cases. But that's really the only time that they kind of completely agree to waive child support, because, like I said, it really belongs to the child. So even though people may not like it, and the other thing is, and this is going to happen if the alimony reform bill ever gets passed too. because child support's a formula, because it is a calculator, so to speak,
Right.
you're stuck with whatever the number is once you put in the accurate numbers. And a lot of times people don't like that number. They say, oh, you got to get me a lower child support. Or you got to get me a higher child support. Typically, child support's kind of low, frankly. And I go, well, the number is what the number is. There's no real argument. So right now, alimony's need and ability to pay. What does that mean? Well, that means that there's a lot of discretion to the judge. If it gets switched to a formula, there's no more discretion, which on the one hand makes things simpler, but on the other hand, you're stuck with whatever number you get.
Right.
And you may not like that number. So, always two sides to every story, every change. So
Yeah, because I could see, like, in his question, can we just, decide ourselves, and then, a year from now, one of the two people in the split or whatever decides, you know what, this teenager's gotten a lot more expensive. I'm not happy with this now, and it backfires on you.
Yeah, and child support, it just is what it is. They don't really take into account the age of the child. If the child's eating more food because they're a teenager now, or whatever it may be. But in any divorce case, typically you're going to have to file the child support guidelines with the court. The court's going to look at those, and like I said before, if the amount's de minimis, if it's kind of under $50, the judge may agree to waive it. Or if you're paying some other expense in lieu of child support, the judge may agree to waive it. The other instances where if it's a long distance parenting plan and one parent's paying for all the travel,
Right.
sometimes they'll agree to waive child support in those cases as well. But otherwise, the judge is basically going to look at the guidelines. As long as they're calculated properly, you're pretty much stuck with what the guidelines are.
Perfect. There you go. Hopefully that answered your question. I think it did. That was some great advice. So if you've got some legal advice, you didn't get to your question today, we can always get to it next week. Just send us an email, ask@DeWittLaw.com, or you can also call or text 407-53-MOSES. Happy 4th of July weekend.
Happy 4th of July to you as well.
Thank you so much. It is the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk with Moe DeWitt of the DeWitt Law Firm.